Hello,
Hi. जी सर.
Uh, Good afternoon,
Chetan.
friends. Good afternoon, friends. Welcome all of you at today's webinar.
Recording has
One more
started.
initiative by Institute of Company Secretaries of India. Today's topic is intricacies in filing of e-form PAS-6. We all are aware that there is a requirement of reconciliation of share capital through audit report on half-yearly basis, and that is mandated under the Companies Act 2013 and rules made thereunder. And the submission of the same is required to be made through e-form PAS-6 with the Register of Companies. So the significance of the e-form is strengthening the corporate governance. So now it becomes imperative. Okay. The significance of e-form is strengthening of corporate governance. So it becomes imperative for the company secretaries, practicing company secretaries, that due care and cautions is being exercised in carrying out the form while adhering the highest standard of professional ethics. So for that we have our dignitary today's C.S. Makaran Joshi sir, who will guide us for this journey. So welcome you, sir. I would like to introduce him. As we all know, he is a very well-known figure across ICSI, but I am trying to introduce him. Mr. Joshi is a practicing company secretary having experience of more than 20 years. He is a founder partner of MMJC. He was a member of Auditing Standard Board in the year 2018. He is a member of Secretary Standard Board also of ICSI since 2019. He was a group convener of guidance note on prohibition of insider trading. He is also member of Allied Law Committee and Legal Representations Committee of Chamber of Tax Consultant Mumbai. He has also written so many articles which has been published in the magazines of ICSI, ICAI and other professional bodies. He is taking lectures at the study circles, seminars organized by ICSI, ICAI and industry associations. So he has a vast experience to address various forums. So welcome you, sir, once again. Over to you.
Thank you, Chetan. And thank you all ICSI, first of all, for giving me this opportunity. I'm sharing my PPT first, and then we can take some question answers which we have received, Chetan. Is that right?
Yes, sir. Please go.
That format is correct. Yeah. Yeah. Can you see this PPT? Can you see the screen? Thank you. Thank you, Chetan. As Chetan was explaining, this is a format which goes towards strengthening of corporate governance. This form and this amendment, particularly Rule 9A, which we refer to, and Section 29 goes into so many amendments. It's in the air, it's in the mind of MCA to introduce something like that since 2018. As we all know, Section 29 has been there since 2014. But the rule, the companies which have to maintain securities in Demat form, that got prescribed under Rule 9A. That happened somewhere in September 2018, which became effective from 1st October 2018. And since it became effective from 1st October 2018, and at that time also, Rule 9 had a mention that the same form which we file under Regulation 55A of the erstwhile depositories regulation, the same form we will file with MCA. That kind of stipulation came in October 2018, and therefore the first half year would have been March 2019, and therefore everybody was waiting that we will file this form, and under which form we will file, because there is no E form, 55A has to be filed. Then we were contemplating that probably GNL1 or GNL2, those general forms we can use. And then somewhere in April 19, MCA clarified that wait, don't upload 55A, we will come out with a new format of the e-form. This came in April 2019. Then what happened is Rule 9A, Sub-Rule 8 of that Rule 9A, which prescribed that 55A has to be followed. That Rule 9A, Sub-Rule 8 was replaced in May 2019, and where they said that it will be PAS-6, which will be the format in which you will be prescribing. Rule 8 and Rule 8A were introduced. 8 was replaced, 8A was newly introduced May 2019. Again, we were waiting that when this new form will come. And then, so the first half year was September 2019. And then again, we were contemplating that which format we should use and all of that. In November 2019, again, MCA clarified that don't use a physical form, we will come out with the e-form. And as soon as we will deploy that e-form, within 60 days of that, you will have to file those forms. That kind of stipulation came in November 2019. And finally, on 15th of July 2020, this e-form PAS-6 came into existence. And therefore, the last due date, 60 days, which come to end on tomorrow, that is 13th of September to 2020. And probably the date will be extended, or at least CFSs we can claim. We will discuss all of these points as we move further. In the meantime, what happened is these were all the amendments with respect to rule, but section 29 also got amended, and that amendment happened in somewhere in July 2019 in Amendment Act. Section 29 was also amended. Now, when all these amendments were happening, and when I was looking at PAS-6 e-form format, and then we looked at the capital, whether it is paid up capital, issued capital is tallying with a physical capital and a Demat capital. Then the question comes is whether you have come out with any type of issue, that is right issue, bonus issue, private placement, or anything like that during the last half year. And then they ask whether promoter director hold shares, whether they hold in physical Demat. So e-form filling is not a big deal at all. And what is the idea? What is the logic behind this e-form, or what is the logic behind this reconciliation, was a question which I was thinking, and therefore I had to go back to, because this PAS-6 we have adopted, MCA has adopted PAS-6 from Rule 55, Regulation 55A of Depositories Regulation, and therefore I tried to look at as to what is the historical legal history, legislative history before this PAS-6. And this legislative history goes to listed regulations or listed company. And before 1996, as we know, the shares were in physical form, and in those days, many companies or many registrars or many players in the market, they have been manipulating the market by printing the false, fake share certificate and bringing it in the market. And therefore, there was no tally as to whether this certificate is a valid certificate or a fake certificate, whether my title is valid, not valid. And then those time, a lot of scams happened in stock market because of the fake certificate getting used in the share market. And therefore, somewhere in 1994, National Stock Exchange came in picture with an electronic trading. And then enactment of Depositories Act came in 1996. And in that Depositories Act, Regulation 55 of Depositories Regulation, they said that since now we have two scenarios, one is physical share certificate and two is Demat certificate, and therefore now there is more complication. Earlier there was only physical, that was the complication. Now we have moved to Demat, but Demat is not the compulsory mode, right? Then the Demat was not compulsory mode. Shareholders were allowed to hold shares even in physical mode, and therefore there were chances that more manipulations will happen. And somebody company may demat the shares which is already for certificate for which is already there in the physical form, and companies may go for dematting shares for which listing trading approval has not been received, and so on and so forth. And therefore, there was a regulation 55, not 55A, regulation 55, which said that every day there has to be a daily reconciliation of this share capital, Demat capital, physical capital, and RT has to do that reconciliation with depository. So that mandate was there since beginning. Till what happened is there is one landmark case, Somani Cement Limited case, and this was one of the reported cases, but there have been many instances which SEBI found what happened is, in this case, company did allotment of shares and got the shares dematerialized also. However, before the shares got dematerialized, stock exchange had not given them in principle approval of allotment, or stock exchange had not even given them approval for trading. But those shares got dematerialized, and then those dematerialized shares, the promoters of the company transferred it to some known names, and then those known names, those known people sold those shares in the market. And therefore, what happened is, in spite of the fact that there was dematerialization of securities, still such kind of frauds were happening. And then there was a chance that company might have paid up capital of say 10 crore, but issued securities which get traded in the market, either in the form of physical share certificate or in the form of dematerialized form. But there were chances that the listed capital, the admitted listed capital on stock exchange, versus the shares which are getting traded on a physical platform or on a digital platform, are more than the requirement. And therefore, in spite of the digitalization of the shares structure in a dematerialized format, still there was a need of reconciliation, and still there was a need for tightening the processes. And therefore, if you see our guidance note, which was issued in 2012, ICSI's guidance note for Regulation 55A, that guidance note also commented on this subject, that there were possibilities of excess getting issued in a Demat form over the admitted capital. Admitted capital is admitted for trading by the stock exchange. So admitted for trading is 10 crore, but dematerialization is 12 crore. This kind of a concept was still possible. And therefore, SEBI also tightened the processes. And then what they said is, unless and until in principle approval from stock exchange is received, dematerialization cannot happen. Right? In principle approval for listing and in principle approval for trading some securities. And only once the dematerialization has happened, only then you will get a trading permission for those shares, and only then the shares can be traded. So a lot of processes were strengthened in the process. But the moot point which I wanted to highlight here is, why this concept of reconciliation certificate was introduced is, this is the background, that physical certificate which are there in the market do not tally with the register of member. Digital certificate which is getting traded in the dematerialized form do not tally with the share capital of the company. In this background, in December 2002, SEBI again came out with a guidance. First, they came out with a guidance to registrar and transfer agents, and they mandated them that you have to ensure that dematerialization of shares shall be confirmed and created only after in principle approval of stock exchange is obtained. Before that, you cannot confirm dematerialization of shares, and where the shares are listed and admission of the said shares with the depositories have been granted, only then you can give permission, otherwise you cannot give. One more mandate which was stipulated to RTA, and this will be applicable even for unlisted public companies. The mandate which was given to RTA is that you should have proper system and processes to ensure that once shares or securities are dematerialized, they don't get dematerialized again. For example, Mr. Makaran Joshi is holding shares in the physical register of member. I got my shares dematerialized, and again then I am approaching for dematerialization of the same shares, and there were instances where registrar has approved those double, triple dematerialization of the shares which are physically issued, and therefore this mandate was also given to the registrar. RTA was also asked to ensure a reconcile on daily basis with the depositories about the shares in NSDL, CDSL, and in physical format, whether it tallies with the paid up capital or not. And then RTA shall also confirm that dematerialization requests have been processed within 21 days. What SEBI also realized, that on one side there is a need that no fake instrument or no fake shares should get dematerialized, and therefore there should be enough processes to ensure that no fake shares should get dematerialized or no duplicate dematerialization should happen. But at the same time, investors should not be at loss, because this process should not take more than the longer period. And therefore they said that there is a process of, from what happens typically is, as an investor also, as a person who might have shares, you might have experienced this, that if you are trying to get the shares dematerialized, you have to submit that your share certificate with the DP. DP submits it to depository. DP is depository participant. He submits it to depository, that is NSDL or CDSL. and gives a confirmation to the issuer. And then issuer means a registrar and transfer agent. And then within 15 days from that, RTA has to give a credit of those dematerialized shares if his register of member tallies with those details. So total of 21 days was mandated to RTA, that not more than 21 days you should take. So SEBI was taking two-way action. One is no fake transaction, and dematerialization also has to happen within fixed period of not more than 21 days. So then this happened in December 2002, and then SEBI issued a circular even to the issuers saying that you have to get secretarial audit done. Now this terminology, this certificate which practicing company secretaries or at that time even chartered accountants used to issue, this certificate used to be called secretarial audit. Now we have MR3, which is a secretarial audit, but this certificate was the first certificate which was called as a secretarial audit report issued by a company secretary, or a chartered accountant was also allowed to issue secretarial audit report. And what that certificate used to provide is that whether total number of shares issued in NSDL, CDSL physical form tally with the issued or paid up capital. Now issued or paid up, they have been using as a synonym. Now we as a company secretaries, we know that they first issue, then subscription, then maybe called up, then paid up, then there may be something unpaid, and in between there is an allotment. We have been studying as a company secretary that issue and allotment are not the same, all of those. So first company issues the certificate, section 42 and all we know. So we treat issue as issued capital and paid up means post allotment, whereas SEBI has been considering issued and paid up as a synonym, because their primary objective was whatever is the allotted capital or whatever capital has been allotted by you after issuing, of course, the shares, that capital versus the instruments which are getting traded, whether that tally or not, that was their primary objective. Difference between issued capital and paid up capital reconciliation seems to be the objective of SEBI. So this is one important point which I wanted to highlight, because the issued capital word also appears in PAS-6. Why, dear friends, why I'm going to 55A? Because our mother of PAS-6 is 55A and now 76, or this secretarial audit report before even 55A. So the concepts of which emerged at that time, similar concepts still exist. Okay, so first condition which of that certificate required is that whether the shares in physical, that is physical share certificate, or in Demat, in NSDL and CDSL, all three put together should tally with the paid up capital / issued capital in the books of the company. So that was number one. Number two, whether register of member is updated or not. Now when they say register of member is updated or not, it means a lot. So if there is a physical shareholder who is holding shares physically, if he approaches for Demat, then in his case, what will happen is they will say that these shares have been transferred to depository's name, and those shares will be transferred in NSDL or CDSL portfolio in the register of member, right? So his individual name will disappear from the register of member, and he will appear as the beneficial owner in CDSL or NSDL, and therefore register of member needs to be updated. And register of member will give you how many are shares in the physical form, and register of member will also give you how many shares are in NSDL or in CDSL form, and then NSDL and CDSL's record will also show you as to how much the shares are held in their end. And that's how a company secretary is expected to reconcile. That register of member will tell him that how many shares are in physical and how many are in Demat, and amongst in Demat he has to procure a certificate from NSDL and CDSL as on cutoff date how much are there in their domain, and then reconcile and see whether it is tallying or not. So that's how this certificate was there. And then 21 days, as all practicing company secretaries would know, that whether dematerialization has happened in 21 days or not, and if it has not happened in 21 days, why it has not happened. This certificate also required to incorporate what are the changes in capital and why are those changes in capital which has happened, and then also as to certify as to whether listed company, whether in principle approval for those allotted shares have been received from a stock exchange or not. Because as we saw in Somani Cement's case, that was a mere basic problem, that the shares Demat got credited before in principle approval was received from a stock exchange. So this is what the certificate emerged. And at that time, the obligation was on the issuer. Issuer company has to submit this audit report on quarterly basis to the stock exchanges. And stock exchange in turn, if they observe any discrepancy in that certificate, they will in turn intimate to SEBI and depository as to what is the difference in the capital, issued capital versus the capital shares which are held in physical Demat and all of that. This happened in December 2002, and then in September 2003, this 55A, the popular certificate 55A, came in. And then there were two changes. One is that this certificate could have been taken from CA or CS. Now they say a qualified CA and a practicing company secretary. So a company secretary needs to be practicing, but chartered accountant need not be practicing. Even in-house, probably an employee CA would have issued that kind of interpretation emerged. And the responsibility which was there on a stock exchange was shifted to issuer, that whenever issuer observes any discrepancy, because so many certificates getting lodged with stock exchange, and stock exchange going through each and every certificate, finding out, then reporting, it was adding to a lot of load on the stock exchange probably, and therefore they mandated issuer, that is the company, only to identify to depository and to stock exchange if there is any difference in the issued capital versus the issued securities, I would say. And because 99.99% no company will have this difference. This 1% company or 0.5% company or 0.25% per company which have such issues, only those issues stock exchange, depository have to look at. Now, once depository and stock exchange are aware, then they will take the action. They may report to SEBI and all of that. So issuer was not required to report to SEBI, which was earlier required to be done so. And then since 2003 till now, even after these regulations getting replaced in 2018, right? Regulation 55A got changed to 76, but the concept still remains the same, that the quarterly certificate can be issued by a qualified chartered accountant or by a practicing company secretary, right? And the issuer has to identify if there is any difference, then he has to report to depository and to the stock exchange. So this is what is coming out as of now. Now, what is the relevance of these 21 days? This is very, very important. Now, 21 days is actually broken down into two sub deadlines, 7 days and 15 days. Now, 7 plus 15 becomes 22. Then why 21? Now, simple mathematics, but I will share with you some of my learnings arising out of it. So, the requirement says, Regulation 74.4 of 2018 regulation, it says that within 7 days of receipt of security, that is, whenever shareholder or a security holder surrenders his physical form of share certificate with a Demat request form to the depository, then within 7 days of that, the DP has to furnish to the issuer. Now, issuer in today's terms would be now a RTA. Within 7 days, he has to furnish to an issuer certificate and also has to intimate to depository. The physical certificate has to reach to the registrar and transfer agent within 7 days of his lodgement, and then within 15 days thereafter, right, actual Demat process has to happen. When he is a registrar or transfer agent is giving effect to this, he intimates to depository that security is that certificates are listed on a stock exchange, right? So it is not an unlisted shares which I am allowing to be dematerialized. Then I have cancelled the physical share certificate. Therefore, the same share certificate cannot be used again. And I have substituted the name of depository in my register. So these kind of declarations he gives to depository, and then finally a Demat credit happen in 21 days. So 7 plus 15, 22, then what is 21 is because within 7 days it has to be lodged to the registrar, and while calculating 15 days, that day of starting also needs to be counted. So there is an overlap between 7 and 15. 1 day there is an overlap, and therefore it is actually 6 plus 15 or 7 plus 14. Am I communicating? And therefore it is 21 days, and that's what SEBI has been telling us. Now, this is part of SEBI Depository Participant Regulation 2018, and as has been mentioned in Rule 9A, these regulations, DP regulations, are as a mutatis mutandis applicable to even unlisted company. And therefore, this 21 days which we see in PAS-6, the father and mother of that process is in depository regulation, and that's how the 7 plus 15 is the thing which a practicing company secretary has to look at before issuing a PAS-6 without any comment. So this is also very, very relevant, I thought. Now before we move to PAS-6, which is the subject matter of today's agenda. Now what are the discussions narrative is that reconciliation is mainly with respect to number of securities issued, that is share certificate and Demat certificate versus the paid up capital. So that's the first reconciliation which a regulator is expecting us to do. And therefore, simply taking a declaration from RTA saying that these many shares in NSDL, these many shares in CDSL and these many in physical mode, and based on that practicing company secretary issuing certificate is not a good idea. That's not the purpose for which practicing company secretary has been mandated to give this certificate. And we are primarily, this responsibility of reconciliation is towards certificates or the Demat credit. It's actually not the issued versus paid up. Although issue versus paid up reconciliation also we have to do, but while doing a reconciliation of issue versus paid up, we should not forget the reconciliation of instruments which are getting traded, which is the primary objective of this certificate. I thought that I will highlight this with enough. I will spend enough time on highlighting this subject. The regulator wants to ensure that there is no excess issue of shares or securities. Now, if you see para 10 of PAS-6, it is specifically asking about this question, that in earlier 6 months period, whether there were any excess Demat which had happened. If there is an excess Demat, then whether that has been corrected or not, and why that excess Demat had happened. Now, that's an area where regulator wants to focus upon. And if you are a listed company, then issuer has to intimate such differences to depository and to stock exchange. So this is very important point. This is one important takeaway of 55A and 76 now. And regulator wants to ensure that Demat process is done in a timely manner. So these are the 2-3 important points which we can copy paste while issuing PAS-6. This is the expectation from a company secretary while certifying PAS-6 or so. Company secretary may certify PAS-6 as an in-house company secretary, or he may be certifying as an attestation because the PAS-6 is required to be signed by company officer and by a practicing professional, whereas 55 or 76 was issued only by a practicing professional. Now this is one major difference with respect to 55 76 versus PAS-6. So a company secretary may sign this form as a company secretary in employment who is a KMP of the company who may be signing this. So he also needs to take care of this particular subject. Now coming to the framework under Companies Act 2013 with respect to these unlisted public companies, which is the topic of discussion. Now what is happening is regulation section 29 was always there, and 29(1)(b) said that. So 29(1)(a) says that company which are coming out with a public offer has to offer all the securities in Demat form only. So 1A is not a subject of 1A small a. So 1A small is about public issue. That's not a subject of discussion, and therefore I have picked up only 1B. 1B is about such class of companies as may be prescribed. Now it may be public or it may be private. It says that such class of companies as may be prescribed shall issue securities only in the form, only in the dematerialized form by complying with DP Act and DP regulation. So this is very, very important principle which in 29(1)(b) is telling us that whenever company is issuing securities, now what is issue of securities? Is it issue of shares and securities, or it is issuing of share certificate, means Demat credit or physical share certificate? Is one important question which I will leave with the audience for the time being, and we will touch upon this subject as we discuss this subject further. Because as I was telling, it is not a reconciliation between issued and paid up. Predominantly, it is a reconciliation of instruments versus issued and paid up capital. So 29(1)(b). 29(1)(a) was inserted, I think, in July 2019, and now 29(1)(a) says that in case of such class of companies as may be prescribed, securities shall be, now next questions are very, very important, held or transferred only in Demat form. Only word is very, very important. Held word is very, very important. Transfer is important anyways, right? So not only that they have to issue certificates in Demat form, but shares are required to be held also in Demat form, only in Demat form. only, no physical, right? So this is one important stipulation which is coming out in 29(1)(a). But interestingly, 29(1)(b) small b and 1(a) small a, big A, does not give timeline as to within how much time I have to give I have to get my SIN number, within how much time I have to get my existing shares dematerialized. All of those timelines are not there in 29(1)(a). Unfortunately, those are not there even in 9(a). Unfortunately, those are not there even in 9(a), but 9(a) has some different conditions which we will discuss as we move further. Now, this is just a broad framework. 29(1)(b) small, 1(a) big, and 9(a) are the things which we have to look at. Now, as far as applicability is concerned, it is applicable. So, such class of companies as may be prescribed has been clarified now by Rule 9(a) that these are only unlisted public companies, and therefore it is not applicable to private companies. And therefore the question comes, is a private company which is a subsidiary of public company, what happens? My dear friends, now this question has also come in one of those some questions which we have got from the participant. A private company which is a subsidiary of a public is a public, and therefore all the regulations which are applicable to public company are applicable to a private company which is a subsidiary of public, and therefore it is applicable 9(a), 29(1)(b), 1(a), all of it is applicable to those companies which by articles and which by incorporation, certificate of incorporation, are private limited, but by default they are public limited company. But in somewhere in I think somewhere in April 19 or so, there was an exemption which was granted. January 2019, there was an exemption granted from Rule 9(a) to certain class of companies, which were those companies, Nidhi companies, government companies, and wholly owned subsidiary companies. Now, if you are a private company which is just a subsidiary, not a wholly owned subsidiary, then you will have to get your shares dematted. If you are wholly owned subsidiary, then you don't have to comply with 9(a). There is an exemption to wholly owned subsidiaries of a public company. Now, inference is that SEBI circular of 31st December 2002, which was issued to RTA for listed companies, is applicable pari materia, mutatis mutandis, for unlisted public companies also, and therefore registrar has to follow those processes as it is, right? Now, as Rule 9(a) has used the word, this is applicable issue of securities in Demat form only by unlisted public companies, and therefore there are some questions. Whether unlisted public company but debt is listed, that means equity is unlisted but debt is listed. Whether this rule will apply to it? Now, as per the definition of listed company, if any of your securities are listed, then you are a listed company, and therefore you are no longer an unlisted public company, although your equity is not listed, but your debt is listed, and therefore then you are out of this, right? Now, this is very, very funny that I am a debt listed company, but my equity can be in a physical form. Another question is a private company whose debt is listed. Now, although it is a listed company but not a public company, so it is first of all a listed company and therefore not an unlisted company, and it is not an unlisted public company, and therefore it is out of this regulation. So, unlisted equity, unlisted debt, okay, or only unlisted equity and unlisted preference, all of those companies will have to comply with Rule 9(a). Is one of the important learning which is coming up, because everywhere in Rule 9(a) and even in Section 29, the word used is not shares but the word securities. The only sub rule 8(a) under 9(a) rule that talks about capital, and that anomaly we will discuss as we move further. But by and large, issuing certificate securities in dematerialized form, holding and transferring securities in dematerialized form, and therefore even for your debentures, you have to get it dematted, and PAS-6 will have to filed or not to be filed. That we will see as we move further. But definitely 9(a) is applicable. You have to issue debentures also in dematerialized form if you are an unlisted public company. Whether debt listed companies need to file PAS-6, so it's a debt listed company, and therefore PAS-6 is out of question because it is only for unlisted public companies. And if you are a debt listed company, can your equity in physical form? Unfortunately, it is yes. Now, if MCA intends to correct this anomaly, they will have to come out with amendment to Rule 9(a). But as of now, it is unambiguous that if you are an unlisted public company, your debt is listed, right? But if your equity is unlisted, then you can issue shares in physical form, you can hold shares in physical form, and all of that. So these are some of the questions which I thought I will share. Now, before we move further on the more nitty-gritties, this change in format also I wanted to highlight. Now, what happened is, as I was narrating in the beginning, Rule 9A, Sub-Rule 8, as we saw when Rule 9A was introduced in October 2018, it said that audit report provided under Regulation 55A of SEBI DPD regulation shall be submitted by unlisted public companies to the register. And therefore there was confusion, and then this anomaly got finished ultimately with effect from 30th September 2019, where they say that every unlisted public company governed by this rule. Now, governed by this rule means every unlisted public company who has securities. So it may be debenture, it may be equity, all of those companies shall submit PAS-6 to the registrar with the fee as may be prescribed. And it will be certified by a company secretary in practice and chartered accountant in practice. Now, SEBI has company secretary in practice and chartered accountant, qualified chartered accountant, whereas there is no such anomaly in PAS-6. This certificate can be issued by PCA or PCS on a half-yearly basis. Because earlier 55 was on quarterly basis, whereas PAS-6 is on a half-yearly basis. So unlisted companies, to some extent, they have been given little relaxation as far as this certification of reconciliation is concerned. Now, if you look at Rule 8 and 8A, see Rule 8A, which was introduced again when this amendment happened, and then Rule 8A says that company shall, right? So company has to comply with these provisions of issuing securities in Demat form even for debentures, right? Rule 9A is also applicable to you, right? But whenever company observes that there is a difference between issued capital and the capital held in dematerialized form, then issuer company has to bring this to the notice of a depository, right? Now, important point is here the word is capital and not securities. And therefore, as of now, what it appears is, even for debentures, it has to be issued in dematerialized form and PAS-6 will have to be filed. But if there is a difference between issued debentures and dematerialized debenture, there seems to be not an obligation on the company. Certainly, I feel that there is a drafting error, or that's not an intention, that debenture mismatch need not be reported by company to depository. I don't think that's an intention, but Rule 8A as it is talking about capital only. And there is an interpretation principle that when two provisions carry different words, then that has to be read differently. Now, when I was going through PAS-6, and then I was wondering what is the certificate which a practicing company secretary is issuing, whether or a qualified company secretary in employment is issuing, whether he is supposed to check Rule 9A, whether he is supposed to check compliance of Section 29 1B 1A, or he just have to simply tally the capital, ensure that there is no gap between 10 days, and then all those fields which are prescribed in PAS-6 he will fill in, or does he have to really check the compliance of 9A and 29 also? And therefore, when I was going through this e-form which was deployed, like any other e-form, look at this certification which is there in this e-form. After you finish once you complete the 16 tabular form e-form PAS-6, and when you come to digital signature affixation, and when you are attesting, when you are signing as a company secretary or a CEO or a director or a manager or a CFO of the company, what do you certify? Let's look at this language. I am authorized by the board of directors of the company by resolution so and so to sign this form, and I declare that. Now, these are words very, very important. And I declare that all the requirements of Companies Act and Depositories Act and rules and regulations made thereunder in respect of the subject matter of this form. So these are very, very important. All the requirements of Companies Act, Depository Act, rule regulation in respect of subject matter of this form and matters incidental thereto have been complied with. Now, if you don't check Rule 9A, which says that promoters, when the company is planning to come out with a right issue or bonus issue or any type of issue of securities, then the shares of promoter, director and KMP has to be in the Demat form only. Now, if you observe during a particular half year, company has issued, come out with a right issue, and promoters' own shares or the directors' own shares or KMP's some shares are in physical form, and if you certify that e-form as it is, without worrying about qualifying, then there is a problem because you have not complied with the provisions of Rule 9A, which is the subject matter of this form and matters incidental thereto. So we as the professionals, while certifying this e-form, either as an in-house company secretary or as a practicing company secretary, we not only have to attest the correctness of the e-form, but we also have to see whether the provisions which are incidental and which are relevant to the subject matter of this form have been complied with or not. Now this is one major alarm which I would like to give to all the people who are submitting this e-form. And if you already submitted, just check whether there is no error. And at least for here onwards, at least try to take care of it if you find there is some gap. Further, a company secretary in employment or a managing director, whoever, he further declares that I also declare that all the information given here and herein above are true, correct and complete. And one of the requirement is whether register of member is updated or not. Right? So register of member is updated, then whether it is authenticated. When you say it is updated, whether the entry with respect to transfer of shares to the depository's name has been made or not, all of those details have to be authenticated by the person who is certifying this. It is hereby certified that the professional, a CA or a CS, PCA or PCS, has been properly engaged. So, a certification is not only about PAS-6 but also about entire provisions of 29 and 9A. This is one important thing which I wanted to highlight. Now, a practicing company secretary might say that this is a certificate which is given by a in-house person, and what I am certifying. Now, what you are certifying, that also let's look at. Me as a practicing company secretary. Chetan, you are also practicing company secretary, right? So, practicing company secretary declares that I have been duly engaged. I have gone through the provisions. Okay, so first is that I am aware about the provision. And I have verified the above particulars. Now, above particulars includes this declaration also, right? I have verified above particulars means this declaration which is given by the in-house person also I have verified, and that I have found them to be true, correct and complete. And therefore, practicing company secretary is also not spared, and you also have to read through 29A and 9A, 29 and 9A on all of that. And there is one more declaration. I further certify that the records have been properly prepared and as per the relevant provisions of company. Again, register of member, whether it is properly updated. Now, if you see register of member, and in register of member you see a transfer entry, and from Makaran Joshi the shares have gone to Chetan Patel and not in Demat form. That means physically the shares have been transferred, and then the company secretary will have to comment about it, right? So this is what, it's a very in-depth review which a practicing company secretary or in-house person has to do, and otherwise it is understood that I shall be liable under 448 of Companies Act. So that have been reading upon while certifying every e-form. So I thought that I will first establish that 55A and 76 is the father-mother. Second, I thought that it's not about certification of just contents, but it is also about the compliances with respect to the transactions which are mentioned in those e-form as far as Companies Act and Depositories Act are concerned. And these are some important points. And now that we are all on same page, now we will move to one by one 29(1)(1)A, what they say in detail, what 9A says, that also we'll see in detail, and then we'll see lot of critical questions around it. It's a non-abstante section, section 29(1), notwithstanding anything contained. So whatever said in anything, you don't rely on any other provision. As far as issuing securities are concerned, it shall only word is very, I wanted to highlight for your purpose, only in dematerialized form. And issue of securities. Now, whether securities will mean even a split and consolidation, that we will see as we go further in some critical questions answer. So, such class of companies now, which is unlisted public company, shall issue securities only in dematerialized form. So if you are coming out with a rights issue, right, or a bonus issue, and some of your shareholders have still not got their shares in Demat, you have to issue shares only in Demat. Now, how do you do that? That is a question, and that is one of the critical questions which I have covered in this PPT, which we will try to answer. That will you say that you will not get shares? Now it's unfair. Okay. Can you give physical share certificate? That's further not as per law. So how you have to balance the two and still comply. So this is 1B, small 1B of 29, and 1A says that in case of such class of companies, unlisted public companies, that means shall be held or transferred only in dematerialized form. And other companies may issue in physical or in Demat. They have choice. So private company may go for Demat, may not go for Demat, but if they go for Demat, they have to comply with depositories regulation. So that's very, very sure in subsection 2 of 29. Now we move to 9A. 9A has many subsections. So the font size has got reduced. So 9A says the first obligation is obligation on the company, obligation on the holder of security. So I have bifurcated into two. Company has a lot of obligation, holder of security has only two obligation. Company has first obligation that issue shall only be in Demat form. It shall facilitate Demat of existing security. That means it has to approach one of the repositories, get ISIN generated, and all of that. Once your ISIN is generated, as per 9A4, inform to all security holders about the ISIN. 9A2 says that before making any offer for issue of securities, bonus, rights issue, buyback of securities, if you are coming out with the issue of right, bonus, or any type of other issue of security, or even for buyback of security, you have to ensure that entire holding, not some, entire holding, and that's what you have to look at whenever you are submitting an e-form. If you see a right issue and if you see some of the shares of promoter held in physical, that means there is a problem and you will have to qualify that in PAS-6. Entire holding of promoter, director, and KMP in Demat. So promoter, how will you determine? In MTT7 is also good enough litmus test for you. Director and KMP is not a rocket science. It's very well understandable. Timely payment of fees. Now this is very important. Timely payment of fees. Sub-rule 5 of 9A says that payment to depository, payment to RTA, whether they have been made in time, whether you have kept twice of the annual money as deposit with them or not, that you have to confirm. And unless and until you are sure that you have paid the fees and you have kept double 2 years fees as a deposit with them, unless and until you have complied with that, you cannot come out with any right issue or bonus issue or buyback of shares or anything like that. And a practicing company secretary, if he is certifying and if he sees that without keeping 2 times of the money as may be agreed between the registrar and the issuer, if the company has come out, then it has to qualify. Then he has to qualify because that's not allowed unless and until you have paid the fees on time. Obviously, depositories and RTA will also take care of their monetary interest. And so, their chances are very weak that they are not paid fees and the transaction is processed. But still, just as a academic discussion, you have to check that the fees has been paid or not. Submission of PAS-6 is an obligation of a company, and company shall immediately bring to the notice of the depository. Depository means NSDL or CDSL, with whomever you have enrolled your security. If there is any difference between the capital, issued capital versus dematerialized capital, then you have to inform. And if there are any grievances of security holders of a unlisted public company, the same shall be filed before IPF also. So these are certain. So IPF can be authority with where these complaints can come, and you have to resolve that. For listed company, there is a scores as a mechanism, whereas for unlisted public company, IPF portal will do that role. Now, what is an obligation on the holder of the security? He has to convert into Demat before lodging for transfer. And not only that, if the company is coming out with the right issue and he wants to participate, if the company is coming out with the bonus issue and he wants to get those shares in his hand, then not only that he has to open Demat account, he also has to get all his entire existing holding to Demat. And that's why we see 1A, which we said that held and transferred. So holding also is required to be done only in a
Demat form. And because of these regulations, to me it appears that in a listed company you have a choice that you can hold shares in, at least in a public category if you are a shareholder, you can hold shares in physical or in Demat form. Only thing is that you cannot transfer in physical form. You have to get your shares dematted. Whereas promoter has to hold the shares in Demat only. But when it comes to unlisted public company, not only promoter but even non-promoter category shareholders will have to hold the shares in Demat only, and they probably will not be allowed to get their shares dematerialized, because 1A says that shares has to be held and transferred only in dematerialized form. And therefore, if you see any dematerialization of shares, you have to raise question and highlight that in PAS-6. Some more questions with respect to whether ISIN is to be obtained and PAS-6 has to be filed even for preference shares and debentures. So definitely ISIN has to be obtained. Separate ISIN will be generated for each category, each class of shares. So even if in equity you have 2-3 classes, their separate ISIN will be generated, and PAS-6 also is required to be filed. Now if MCA, if you look at PAS-6, all over the PAS-6 it has the word capital. It does not have the word securities, and therefore there is an anomaly. And Chetan Bhai may take up this matter through Central Council to MCA on this clarification that whether you want PAS-6 for debentures or not. But as of now, as it goes, if you look at Rule 8, it is coming out very clearly that PAS-6 will have to be filed. So if PAS-6 only talks about capital, in capital only you mention about debentures and attach a clarification later that this is about debenture. But since E-form talks only about capital, we have filled in as it is, whatever is available. The best, to the best of our possibility, we have filled in the form. Next question is if company has obtained ISIN, but some security holders have not converted their securities in Demat, is it a non-compliance? It's not a non-compliance as of now because there is no timeline given to them. Physical to Demat, when should they go? There is no timeline. But if you want to transfer, you have to go into Demat. If you want to get any shares allotted in your name, then you have to convert your existing capital also in Demat. And therefore, if a practicing company secretary sees that company has come out with the right issue and still some shareholders have retained their existing shareholding in physical format only, then he will have to mention about that qualification in PAS-6. But if there is no transaction which has happened in 6 months, right, in first 6 months, or because the already first 2 6 months period is over, 1st April till 30th September and 1st October to 31st of March, these 2 PAS-6 we will be filing now, and if there are no transactions, you did not qualify. If shares debentures are redeemed during this period, can they be redeemed even though those are in physical? Now if you look at very carefully the wording, the restriction is on buyback. You cannot come out with a buyback unless and until your promoter director KMP has held the shares in Demat form, right? But redemption does not even stipulate that requirement. That even if your promoters have even not done the dematerialization, still you can redeem your existing physical preference shares or debentures. There doesn't seem to be a bar in the beginning. As we move further, the rules will change because the shares and debentures here onwards will always be issued only in dematerialized form. And then you cannot redeem them in physical form. You cannot allow them to convert into physical form. So redeeming them in physical form does not arise. That was a transition question. Can company reject transfer of securities which they have approached for physical? You have to reject. You have no choice. You have no choice. You have to reject, and if the company has not rejected, then PAS-6 will have to be qualified by a practicing company secretary. Whether mandatory Demat is required even for CCD, when he is sure that I will be getting converted into equity. Unfortunately, CCD is also security, and security will have to be issued only in Demat form, right? And if you have already existing issued CCD, then you have to get ISIN and then convert into. Once you convert them into equity, then this ISIN will get cancelled, and the new shares will be added to the existing ISIN of an equity shareholder. If some securities are in physical form only, then can company never go for buyback of shares? Now buyback, what they say is your promoter, director and KMP should be in Demat form. The provisions does not say that even non-promoter category or non-director or non-KMP category shareholders should also be in a Demat form. What they say is, as far as security holders are concerned, before transferring or before subscribing to the issue, they have to get their shares dematted. But as far as buyback is concerned, there is no such restriction, and therefore in a transition period, if you go for buyback, non-promoter category can go for buyback even in a physical form, in a transition manner. As we move further, everybody is going to be in Demat mode only, right? If company gives buyback offer, and whether PAS-6 will have to be qualified, of course, PAS-6 will not have to be qualified if it is during this period. If company does right issue, can it offer physical security holders? That means before coming out with a right issue or bonus issue, first of all, company has to ensure that all fees are paid. Then the company has to ensure that whether my promoter, director and KMP, the entire existing holding is in Demat form or not. Once I am satisfied about these two conditions, then I can come out with the right issue. Now when I am coming out with the right issue, there are some other non-promoter, non-director, non-KMP category shareholder who are holding shares in a physical form. Now you will have to offer them those shares or security. You have to offer them those shares, but before allotting them the shares, you have to ensure that they have got their existing securities dematerialized. And if they have not got their existing securities dematerialized, then Demat credit with respect to those shares cannot go to them, and those shares cannot be allotted to them even. As far as bonus issue is concerned, now I will also urge Chetan Bhai that we can also take up this subject, because if there is a specific directive about how should company deal with as far as right issue and particularly bonus issue is concerned, because bonus issues get credited to the Demat account if the shares are in Demat form, and if it is in physical form, they get in a share certificate format. But now I cannot issue physical share certificate at all. I have to issue in Demat form only. Now, what I am proposing, what I am suggesting in this PPT is that a company can open a separate escrow account where all these physical shareholders' shares will be dematerialized and credited to that account. And as soon as the existing holding is dematerialized by that shareholder, those securities which are in the escrow account can be transferred or can be passed on to those shareholders, because getting a bonus is my entitlement, right? And unless and until I get the securities dematerialized, I will not be able to get it. That is also given. So how do you comply with both? So I think this is the way you can think over it. Now, as far as PAS-6 modalities are concerned, as we know, it is a half-yearly basis, and within 60 days from the end of half year, this form will have to be filed. The first trigger is trigger from 30th April 2019, and extended due date. Then ultimately, finally, it is coming to 13th September 2020. And both for 30th September 19 and 31st March 2020, PAS-6 will have to be filed before that last due date is tomorrow, that is 13th of September. Forms not mentioned in the list of CFSS, but CFSS is an umbrella scheme which has come out for all the forms and all the returns which are required to be filed, except the authorized capital, increasing authorized capital form and charges related form. All other forms can be filed under CFSS scheme, and therefore I feel that even PAS-6 can come. And Chetan Bhai, you can comment on it maybe, that when the immunity form will come, there has to be a proper drop down with respect to PAS-6 also. Otherwise, what will happen is from on 13th of September onwards, some company secretaries, some companies will file form, and there will be no late fee because there is anyway moratorium which is going on till 30th September. But whether I should be able to claim the immunity so that there is no penalty under section 450 levied on the compliance officer or on the company, and so on and so forth. So these are some teething issues which we may have to deal with. If you look at comparison between 76 versus PAS-6, the important point with respect to PAS-6 is that details of shares of promoter, director, KMP in Demat only, physical is not possible, right? And those details also go in this PAS-6. This is an additional data, and it is jointly certified by a company person and a practicing company secretary. And it is about securities, whereas 76 is only about shares. So these are some important differences between Regulation 76 and PAS-6, which I thought can be relevant. And these are some basic information with respect to PAS-6, which we all know. I will skip this form. I will skip this particular, this change in capital, holding of promoter director, whether within 21 days Demat credit has happened or not, all of these details, and ISIN is one important thing. Unless and until you have ISIN, you cannot file PAS-6. And therefore, ISIN creation is the first step, PAS-6 filing is the second step. And few of the questions which we have got are in this subject, that if I have not generated ISIN as on 31st of March 2020, can I generate ISIN now and file PAS-6? In my view, yes. PAS-6 filing is important. There was no threshold there was no time period within which ISIN has to be generated. Obviously, after September 2018 or after 1st October 2018, you were not allowed to issue shares in a physical form anyway. But there was no, if there is no allotment which has happened or there is no transfer which has happened from 1st October 2018 till now, then there is no non-compliance. ISIN can be generated even now. As I have mentioned that these compliances also the company secretary needs to check as to whether there is a default in the payment of fees to registrar depository, whether the security deposit has been deposited more than 2 years or more than that, whatever is an understanding between company and RTA or depository, that has to be complied with. And compliance with rules, regulations issued by depository and SEBI, whether that has been complied with or not, that is also to be checked. And therefore, do we need to check compliance of this in PAS-6? Now what happens is, unless and until you have done this compliance, you cannot come out with any type of issue. And this is also subject matter of this form, and therefore this needs to be checked by a practicing company secretary. If there are multiple, some more critical questions. If there are multiple securities, do I need to generate multiple ISIN? Yes. And if I am generating multiple ISIN, do I have to file multiple PAS-6? Yes, you have to file multiple PAS-6. If company has not yet obtained ISIN, can I still obtain ISIN and file PAS-6? Yes, you have to obtain ISIN now and file PAS-6. Otherwise, Section 450 non-compliance will get triggered. Filing PAS-6 is a mandatory compliance, whether you have got your shares dematted or not. That means you have to first get shares dematted. You have to first generate ISIN and then file PAS-6. Can company obtain ISIN now? Yes, it can always obtain this. What is the last date for submission of PAS-6 for two PAS-6? 30th September. If PAS-6 is not filed, what is the recourse? You can still take a recourse under CFSS even if the due date is not extended and file an immunity form. And are there filing fees? Yes, there are filing fees, but till 30th September, probably MCA will not generate any late filing fee. But even if there is no late filing fee, let's not get complacent. We have to get this immunity form filled in so that there is no penalty prosecution. As we all know, Section 450 is a section like a khuda. Jiska koi nahi uska khuda, or Section 450. Wherever there is no penalty prescribed, 450 becomes applicable. In this provision also there is no penalty prescribed, therefore 450 is applicable. And as per the Amendment Act, amendment provision, 450 is also going to get in an adjudication mode, and therefore 1,000 rupees penalty can be levied by ROC itself without going into prosecution process. And therefore we have to be very, very careful. Even if you submit till 30th September, ensure that immunity form is filed for that. Some practical points which we will take up. I think just 5 more minutes, Chetan, and then we can take the balance question. Whether issued capital is issued capital or a paid up capital. So this is a screenshot of that PAS-6, and therefore, as I have been highlighting, actually they meant to reconcile capital, allotted capital versus the security. But since the word used is issued, therefore let's mention here issued capital. And more important point is, although the word here is issued capital, but we are not supposed to mention the amount, but we are supposed to mention number of shares. So number of shares issued will have to be mentioned. What are the scenarios when there can be difference between phi A and phi E? So these are some examples where issue has happened, but the pending allotment is yet pending. Whereas there can be another scenario where issue had happened, but not yet subscribed. Or issue has happened, but corporate action is not complete. Or issue has happened, but it was partly paid and some shares got forfeited. Or bonus issue, but some shares are in physical holders and therefore there is a gap. Or PAS-3. Now I have come across in my life, professional life, that PAS-3 have been revised by some companies. Now, because there was some error. Maybe the name of the allottee was wrong, or the number of shares was wrong, or the issue price was wrong. Something going wrong. PAS-3 getting revised. Now what will happen is, issued capital PAS-3, if it gets revised and dematerialization has happened based on old PAS-3, and subsequently if company has revised that PAS-3, it's a matter of concern. And therefore I urge to all the practicing people that whenever you are certifying e-form, ensure that just go through the view documents on MCA and see how many PAS-3 have been filed during this half year. And whatever PAS-3s have been provided to you by the company, the client may provide you only the revised PAS-3 and don't provide you the earlier PAS-3 and vice versa. And therefore then there can be a difference which we have to capture into this e-form. So these are some of the reasons why there can be gap between 5A and 5E. And when you are verifying, you should not only take a declaration from RTA, but also look at what is the balance sheet. Look at balance sheet, look at your all MCA forms, look at beneficial ownership position, look at register of members, like look at screenshots of NSDL and CDSL, take their screenshots of what is the holding in the Demat form. Also look at all the board resolutions and all of that, so that you get to know as to which PAS-3 is right and whether the PAS, because Demat does not happen unless and until a board resolution and a PAS-3 is lodged with them. But if the company subsequently revises that resolution saying that there was a typo error in the PAS-3, then we have to be very, very careful about it. A few more questions. Connectivity. So, for example, an unlisted company can have connectivity with NSDL and CDSL both, but I am allotting shares to a shareholder who are holding shares only in NSDL. Now, whether I have to select in CDSL also as yes. Now, whether once you get ISIN generated from NSDL and CDSL, all corporate actions will have to be updated to CDSL and NSDL, irrespective of whether your shareholders have Demat account in NSDL or CDSL. If an individual is a promoter as well as director as well as KMP, then in which category I should mention? In all three or any one? I think you can mention in any one. Attach a clarification letter that Mr. X I have counted in promoter, but he is also a director, also a KMP, but I have not mentioned it in 3 times. Because if you mention it at thrice, then MCA may wrongly take it as there are total. It may add it up. And if your entire capital is held by promoter and he is the same director and same is the person KMP, then this number will not tally with your issued capital. And therefore better to mention only in one of the boxes so that there is no anomaly. And this last question is on this 21 days. How do I verify this 21 days? As I had mentioned, DRF, that is Demat request form, is an important document which a practicing company secretary can look at. DRF provides a stamp which is stamped by designated depository participant and also a stamp of a registrar and transfer agent. And therefore these 2 stamps will tell you what was the date of lodgement, what is the date on which RTA received, and what is the date on which RTA the shares have been credited, that you can check from screenshot from this depository site. So that's how practicing company secretary will have to check 21 days compliance. That's an important point which I thought, that DRF will have to be checked with respect to all the Demat requests which you have received during this particular half year. Now, before we end, some of the illustrations where PCS needs to qualify. For example, if you see in PAS-6, the company has come out with a right issue or any type of issue, and if you see some of the promoter, director, KMP are holding shares in physical form, then it will have to qualify. These are illustrations. I have narrated that in the course of PPT, but I am just revising it. If the register of member, if you see any transfer which has happened and in a physical form, you have to qualify. Other shares are held in transferor's folio in physical form. So when you are transferring the shares, not only those shares but entire shareholding needs to be dematerialized. And if you see anybody who has transferred the shares in Demat form but his other shareholding continues to be in physical form, that is also a qualification. If physical share certificates are issued in a right issue or bonus issue, then you have to qualify. Pursuant to split, you have to qualify. Pursuant to duplicate even, this is my individual opinion, that issue of securities has to be here onwards, has to happen in Demat form only, and issue of securities will have to be considered as Demat credit or any issue of share certificate. So it's not only about whenever your capital gets increased, but even if there is capital is not increased. For example, split or consolidation, capital value does not increase, but the number of new instruments get issued, duplicate new instruments get issued, then it is not possible. And remat is also not possible, is my submission. The last three points are my interpretation, and MCA may clarify it at appropriate time. And these are some important things which you have to keep in your record before certifying PAS-6. And therefore, dear friends, what we looked at is Regulation 55, and the logic of Regulation 55A is very, very important. And then we looked at the declaration which we give while certifying e-form. And then we saw what all things which a practicing company secretary has to look at. Chetan bhai, I have finished with my PPT. We may look at some questions which participants have raised.
Yes, sir. We have received some questions. We will try to take up some of them. Sir, the first question is from Achal Gupta. She is asking, if a company is non-working and do not want to take ISIN number and further want to convert into private limited and has not filed PAS-6, what will be the consequences?
Consequences will be Section 450. 1,000 rupees per day on the officer and company, and as I mentioned, 450 is also getting in adjudication process. Therefore, MCA ROC can levy this penalty without having to prosecute you. Therefore, even if you want to convert in future into private, as of now you have to get shares into Demat. You have no choice whether to generate ISIN or not to generate ISIN.
Correct. Thank you, sir. The next question is from Tulika Bansal. She is asking, if ISIN number generation is under process, what would be the penalty on late filing?
Yeah, that as I mentioned, the penalty will be 1,000 rupees per day. But as CFSS can come handy till 30th September at least, you can hurry it up. And I don't know if MCA extends CFSS further, then that's a bonanza. But as of now, you can say that till 30th September at least you can complete and file immunity form definitely.
The next question is from CS Priya. What is to be mentioned in point number 8 of the form if promoters are also directors of the company? Whether to mention their holding in promoter tab or in directors tab?
Yeah, I think we discussed any one category you mentioned and attach a clarification that the same person is also a director and a KMP. But I have mentioned for the purpose of calculation in one category only, so that there is no duplication.
Yes, sir. Next question is from Subhash Mittal. For point number 10 and 11 of PAS-6, in which situations and circumstances this point will be applicable to a company?
So, para 10 is exactly identifying the problem for which 55 was introduced. That is, capital is 10 crore and Demat happened of 11 crore. Right? So, excess Demat is the subject matter of their inquiry. Right? And therefore, the para 10 is also asking that in last half year, if you have identified any excess Demat, then mention what happened about that. Now, the query which has been raised is in which situation there can be excess Demat. Now, the query, either it can be fraudulent or it can be an error. Now, error can be in, for example, I have seen such situation that the money is received and there was some confusion as to, so for example, an individual gives 10 crore as a loan and 10 crore as a capital, and he was offered say 20 crore of share, and he has said that this, I am a director, I am giving this as a loan and this as a share, and company secretary and while drafting minutes, he said that 20 crore shares are allotted. Okay, and the director also signed those form, and depositories were submitted that PAS-3 and resolution, and subsequently somebody realized that no, the allotment was only 10 crore and not 20 crore, then that's an excess, because you had in the books also you have passed an entry for only 10 crore, whereas you have given a Demat credit of 20 crore. This is a classic example of a excess Demat credit, and it's a very messy situation. And don't ask me how to resolve this. That's an assignment for me. But but these are some classic examples of how either fraudulently, in Somani cement case, TB claims that it's a fraudulent, obviously, and the promoter said that I was not aware and all of that. And sometimes some simple error can create such mess, which can come in first para 6 and then para 10 and 11. Yeah.
Yes, sir. Next question is from CST Siva Kumar regarding a subsidiary and step-down subsidiary. Is filing of PAS-6 applicable to the subsidiary and step-down subsidiary of a listed company? What happens when the subsidiary and holding relationships comes to an end in middle of the financial year?
Yeah.
What
So I
are
will
the
take it.
consequences where the such subsidiary is yet to be demat in shares?
Okay. So yet to be demat is the simplest answer. You can copy paste earlier answer. As far as private company, which is or step 1, step 2, step 3, beyond, wholly owned subsidiary and beyond that too. You cannot go beyond 2, as we know. Anyway, so subsidiary is subsidiary, right? You have to get your shares dematted unless your WOS, that is wholly owned subsidiary. Wholly owned subsidiaries have been exempted. Now, so if you are wholly owned subsidiary, you don't have to get shares dematted. If you are not a wholly owned subsidiary, you have to get your shares dematted. If at a cutoff date, say 30th of September, you were no longer a subsidiary, even forget wholly owned subsidiary, you are not even a subsidiary. And if you are a private limited company, now what is your status? That also you have to look at. Whether you are a private company or a public company. If you have been incorporated as a public company, you are anyway a public unlisted company, you will have to get your shares dematted. If you were private limited company, but because listed company was your holding company, therefore you had become public company. Now you are no longer a subsidiary, then you are a private company. Then this further subsequent getting shares dematted or PAS-6, nothing of this is applicable to you.
Correct, sir. Next question is from CS Kashyap Shah. A company secretary was appointed in February 2019 and resigned in December 2019. In the form PAS-6 for September 2019, while filing the details of the company secretary, error message appears that the company secretary is not associated with the company. In this situation, should we process the form without mentioning CS detail for the September 2019 half year in the form?
I think what MCA is they might have done validation, and whoever is company secretary as of today, only his name is accepted and other earlier names don't accept. So either you don't mention or mention today's company secretary and attach a clarification later that during this period this was a company secretary. Either of the things are okay. And it is a non-mandatory field.
Correct, sir. Next question is from CS Pinaz. If in case of an unlisted public company where there is no operations since 3 years and it is going to apply for a closure of the company shortly, is it necessary to convert the physical shares to demat form and comply with the requirement of filing e-form PAS-6?
Now, if you already applied or if you are just about to apply, a practical view is that you don't need to do.
Yes, sir.
No, this is a very practical view. Why? Because first of all, by law you have to do. Okay, by law you have to do, and there is a non-compliance also. But in strike off, ROC does not insist on past e-filing of forms, and they take a indemnity from a director that if the liability is your personal liability. So long as you are ready to take that hypothetical risk, you can still proceed with. But if it's a far-fetched, मुझे company बंदी करनी है, thought level नहीं, then you finish it. Better you finish it now because 450 may get triggered.
Correct, sir.
And how many years I am in operation or how many years I am not in operation, I think that is irrelevant. You are a public unlisted, you have to get your shares dematted.
Right, sir. Next question is from CS Hemraj Mistry. He is asking if the issued capital of rupees 5,10,000 and paid up share capital of rupees 5 lakh and all the shares are in the demat form with the CDSL, which are 98.04% of the total issued capital, then my total was not tallied in point number 5. Therefore, which amount should I mention in the issued capital column?
Mention 510 and 5 and give a reason that the issued was 510 but subscribed and paid up was only 5, and that's why there is a gap between issued and paid up. Actually, MC and SEBI both were not much worried about lesser, paid up, demat is less, they are not worried. Demat is more, they are worried. So, better, as I have been saying, issue of securities, it has been used in two terms. That is, one is instrument issue and two is issue of, issue under 42 or 179, for which we pass board resolution and all of that. But to be on safer side, it is better to take issue whatever we understand as a company secretary's issue, mention that as an issue, and it is harmless. You can always justify the reason. Yeah.
Next question is from CS Vicky Kundalia. He's asking, if there are three ISINs against equity shares, Class A equity shares and preference shares, the three forms shall be filed. Although the field of issued share capital in each of the form would be against the specific ISIN number, or would be the total share capital of the company?
Actually, all these questions are. My compliment to all the participants who have raised this question, and I'm happy that the other participants are getting advantage of this question answer. This is very classic exact case where can I write issued capital? So, for example, I have a 15 crore issued capital, 5 crore Class A equity, 5 crore Class B equity, and 5 crore preference. Now, should I write 15 or 5? Now, since I am filing for ISIN wise e-form, I will be filing. And therefore, it is more logical not to write the total issued capital, but the issued capital with respect to that particular ISIN, and attach a clarification letter that my total issued is 15, but issued for Class A is 5, and therefore I have mentioned 15 crore as issued capital. So that 447 and 448 does not get triggered even in remotest possibility.
Right, sir. Next question is from CS Kanak. Possibility cases for the situation arises when 5A and 5E have a difference.
Yeah, I think I have shared 7-8 examples in the slide also. Kanak, right?
Kanak,
what is it?
Yeah.
Kanak, I hope you would have got this answer. And if you have missed during the course, probably this video will be available on YouTube, Chetan?
Yes, sir. Immediately after completion of the session.
So if you have missed that particular point, you can refer, because I had given a lot of examples. And again, those examples are of illustrative nature. That's not an exhaustive. I'm not saying that these are the only possibilities, but these can be possibilities.
Yes. Next question from CS Mohan Kumar. Is ISIN mandatory for deemed public company having paid up capital of rupees 1 lakh only with 2 shareholders only? What is the last date of filing PAS-6? I think वो cover करने की जरूरत नहीं है. We already covered. So you please answer first question. Deemed public company, yes, having 1 lakh paid up capital and 2 shareholders only.
Now let's remember, everybody can look at this perspective, that in Companies Act 1956 there was section 43A, which used to talk about deemed public company, and then there were three categories: private company, public company, and deemed public company. Whereas now, public company definition itself says that a private company which is a subsidiary of public is deemed to be public. That means it is public only. Once a private company is subsidiary of public, it has to comply with all the requirements, all the provisions which are applicable to public company only. And therefore, whether your capital is 1 lakh or 1 crore or 5 lakh, it doesn't matter. Unfortunately, my dear friends, ISIN will have to be generated.
Next question is, if an unlisted public company's share is not in Demat form as on 31st March 2020, but later on in August 2020, the process of Demat of shares were completed. In this case, is the company required to file PAS-6 for the period of April to September and for the period of October to March 2020?
Yeah, it will have to be filed. Now what you will do is you will mention ISIN number, but you will be providing the details as at 30th September and as at 31st March. And therefore, your entire capital will appear in a physical form. Now, unfortunately, if you have issued or transferred any shares, then you have trouble. Then it will come in para 16, where a certifying professional will have to comment about it. There is a last box para 16.16, where those details will have to come.
Next question is, I am trying to file PAS-6 for the September 19 and March 20. I am getting pre-scrutiny errors as my membership number is not associated. I think we have covered.
Yeah.
Okay, whether these provisions are applicable to wholly owned subsidiary private company of unlisted public company? You have
No.
clarified.
Wholly owned subsidiary is exempted.
Exempted.
But remember one thing, wholly owned means wholly owned. Okay. So only one share is allowed to be held. For example, if you are a public company, you will have 7 nominees who will hold on your behalf, and beneficial ownership disclosure under Section 89 has to be filed. If that is not filed, that means those 6 shareholders are holding shares on their own, and those companies then will not be considered as wholly owned, and neither they will get this exemption of getting shares dematted. So be careful about that. Yeah, Chetan.
Whether PAS-6 is mandatory for unlisted government companies exempted from Demat?
No, they are exempted, so not required. Nidhi companies, government companies, and
They are
wholly owned
exempted.
subsidiaries. Yeah.
Long back it was exempted.
Right.
Yes. Next question is, whether annual fees and security deposit fees paid to depository and RTA by the company is required to be checked and confirmed? Yes.
Yeah.
You have answered. Okay, sir. I think next, some of the questions are already covered, so I am not repeating it. So we have completed all the questions so far we have received. And sir, I have also
one more point, Chetan.
Yes, sir. Please.
I also thought that I will share one more point here. That
Please, sir.
Adobe 11 version has some error. Okay, Adobe 11 version will not allow you to fill in the form properly, and therefore any version after Adobe DC onwards, because many people have been asking this question as to I'm not getting able to fill up the form properly, it does not capture the detail. So Adobe DC onwards, any version is good, is one important point I thought I would share.
Okay, sir. So that's it. We have completed all the questions so far we have received. Sir, thank you very much. You have covered you have responded to all the questions raised by our members, and now I am sure now it is not an intricacies. It will be very easy task for our practicing company secretary, and they will be able to do their job very efficiently. I am sure it will be a very worthy sessions for them. And sir, I have also noted your suggestions during your sessions regarding the bonus shares in Demat form, regarding debenture is not mentioned in PAS-6, and the inclusion of required fill in the fresh start scheme. So I will definitely convey to MCA through ICSI platform, sir.
Thank you, Chetan.
Thank you very much, sir, for sparing your valuable time. Sir, as a token of love and affection, we would like to give you a Shahid Ki Beti certificate. So may I request to admin, please present Shahid Ki Beti certificate to Sri Makarand Joshi, sir. Thank you, admin. Once again, thanks to all the participants, my president, vice president, and my council for providing me an opportunity to host these particular sessions. Thank you, sir. Jai Hind.
Jai Hind. Thank you, Chetan. Thank you, SCSI. Thank you, participants. Bye-bye. Good day and have a nice weekend.